Hello, and welcome to this presentation, where we'll be diving into different topics such as duty of care, non-delegable duty, and vicarious liability, along with some key cases which have framed the history of medical negligence regarding the topic within Malaysia. Now, to begin with, a doctor owes a duty of care when undergoing diagnosis, advice, or treatment. The case of R.V. Bateman stated that there is no need for a contractual agreement if the person establishes themselves as a skilled and competent practitioner. In the case of Kaur Nagma versus Nagma in 1982, the ratio stated that doctors in Malaysia are held to the standard of reasonable care and competency to that of any medical practitioners internationally. Furthermore, the case of Barnett versus Chelsea is an English case which was in 1969. And this case failed due to the causation, such that it was then established that the but-for test as arsenic poisoning would have killed a man either way. However, despite the case failing on the grounds of causation, it was then held that the doctor still owed a duty of care the doctor still owed a duty of care and was still held under negligent as the duty of care was breached. Now, in order to address the question at hand, one needs to look at the fact that there is a cardiologist consultant and a medical resident officer. These both have different standards of duty of care. The concept of duty of care first arose in the case of Donahue versus Stevenson. This relates back to general tort rather than medical negligence, but I will later explain how it is interrelated. The duty of care arises to those who are closely or directly affected by one's act. It is such that reasonable care must be taken to avoid any sorts of injury to your neighbor. This can be in the forms of acts and omission. So one must ask, what is your neighbor? Your neighbor is someone that you ought to have been in contemplation with. Thus, the case of R.V. Bateman was thus applying Donahue versus Stevenson to the case of R.V. Bateman. It was seen that a doctor, if he or she claims to possess any specialized skills and are consulted due to this relationship, they thus will have a duty of care arising because they established that they have such skill and care, and such skill and care must be used towards the betterment of patients. Furthermore, there are English cases too that are being endorsed in Malaysian courts. Such a Malaysian case can be seen to be Fu Fiona versus Dr. Su Fuk Mun. This is a 2007 case where courts held that the main aspect that causes a duty of care to arise is a doctor-patient relationship. Without this, there is no duty owed. This can be applied to the case as we see that Majori came into the emergency and the resident medical officer voluntarily came to her assistance. From that point onwards, there was a duty of care established. Further, the case of Khao Nan Seng versus Nagma, which was previously mentioned, says that the duty is to exercise fair and reasonable standard of care and skill, that of an ordinary competent doctor. Again, this case involved a doctor failing to monitor blood flow of a patient after applying the plaster of Paris, leading to an induced Garnier's leg, which was amputated. Federal courts in this case held that the practitioner was liable to that of a duty of reasonable care, and this reasonable care was not provided. The key ruling set this under Malaysian common law, which was that a doctor owes a duty of care as per the reasonable skill and competency that of an ordinary and competent practitioner. Now moving on. When looking at how the resident medical officer addressed Majori, there are a few steps that need to be considered in order to conclude if a duty of care was owed. First, it is important to notice that Majori came into the emergency department of a private hospital. I will first look at the stance on Malaysian statute governing the duty of care, and then reflect on some local judicial precedent under common law. To begin with, the resident medical officer worked at a private hospital, and this implies that he or she possesses special skills and is a doctor. This is in fact important in determining the duty of care when looking at common law, which will later be addressed later on. Secondly, as both doctors working in a private hospital, they're bound under rules of Private Healthcare Facilities and Service Act of 1998. This act, under Section 38, provides that one must uphold a duty that any licensed facility where there are practitioners should be implementing emergency procedures and on any should be implementing emergency procedures on any persons requiring such treatment or services, thus showing clearly how there is indeed a statutory duty in private hospital emergencies to attend to a patient. Furthermore, under Section 2 of this Act, under Section 2 of this Act, this section of interpretations makes it clear that the service of which there is a duty of care can be provided includes that of making a diagnosis. Linking back to the question, this can be seen that as the diagnosis of angina from the resident medical officer. More so, under Section 4.2, subsection 3, the Malaysian Medical Council of Good Medical Practice 2019 holds doctors upon a moral duty to provide emergency medical treatment. It also goes on to clarify that any refusal to provide treatment can be taken as unprofessional. However, this does not hold doctors up to a legal duty, moreover, just a moral duty. It lies more as a persuasive argument towards providing duty of care. Now, to introduce the problem and state the legal difference between non-delegable duty and vicarious liability, one must understand that when looking at the duty of care under common law, the law imposes that when a doctor voluntarily enters a relationship with a patient, from that point onwards, there is a duty that has been imposed. This refers to the doctor-patient relationship. The case of Ang Yu Meng and Anor versus Dr. Sashikan Arunalasam and others of 2011. In this case, the facts go as such. The first defendant was undergoing an internship and was a qualified medical doctor. When he attended to a child later on who died due to myocarditis brought by acute septicemic, Lord Supanglian ruled over here that the law imposes no duty of being a good Samaritan until only there is a doctor-patient relationship. That is where the duty arises, such that in the case if the medical officer wouldn't have attended to Majori, there would have been no duty. The duty only began as per the voluntary attendance. Secondly, after establishing a doctor-patient relationship, one must see if Majori was given the legally required standard of care as per the duty of the resident medical officer. Now, the law refers back to the point of providing diligent care, knowledge, skill, and caution. This is affirmed in the case of Kaur Nen Seng versus Nagma and others. And the fact of this case is that, relating this case to the facts of the question, is that the doctor Majori was attended by was in fact a resident and not an experienced doctor. So we can conclude thus so far that the resident medical officer has a lower range of experience, and this can be taken into consideration. However, the law does not differentiate between this. Despite there being a professional experienced doctor versus somebody who is just entering the field, the law tends to look at both of these people as one in terms of they do not impose double standards as per levels of experience. Now, when looking back, common law seems to provide a more conservative view on being a good Samaritan as compared to statute. So when the medical resident officer in question attended to Majori, only then the doctor formed a doctor-patient relationship. Consequently, a duty of care arose. This is also extended to that of the consultant cardiologist. Both of them, under statute and common law, owe a duty of care. The duty of care can be seen to have extended as well, because the duty of care begins at the point of voluntary acceptance, and it also goes on to the point of diagnosis and treatment of the patient. The diagnosis and treatment of the patient can be seen to have spilled over onto the consultant cardiologist, as the consultant cardiologist was indeed responsible for the confirmation of that diagnosis via an ECG. Now, when looking at issues of liability, Malaysian law governs liability for medical officer different from that of a consultant cardiologist. The former is said to be an employee, whereas the latter is recognized as an independent contractor. Therefore, I will first begin by addressing the laws pertaining to the medical officer. Now, the law operates this area stating three main questions that must be asked when enforcing liability. The first is to look at an act or omission, whether it was a tort. The second was the person who committed the tort, was he an employee or an independent contractor? And the third was this negligent act committed during the course of the said employment? So, on application to the question, the main concept which determines if the hospital can be held liable on behalf of the resident medical officer relates back to a key concept under tort law, vicarious liability. Under the judgment of Lord Millett in the case of Leicester v. Helsley Hall, this doctrine acts as a strict liability. The legal doctrine is one of the most fundamental English law principles, with the Latin origin under qui facit per eliam facit per se. This Latin phrase implies that any action done by a man, he must thus sustain reasonable care not to cause harm to his neighbor. This is a form of strict secondary liability, which originates under another doctrine called the doctrine of respondent superior. This poses the idea that there is a master on application to this case, which can be seen as the hospital, who is responsible for the negligent acts of his servant, which in modern day medical negligence can be said to be the employee, aka can also be said to be the resident medical officer. This concept paved its way into cases of hospital liability where negligent medical staff were beginning to be recognized to file a suit under vicarious liability. Under common law, the case of Middleton Fowler Salk also provided further clarification that vicarious liability operates via the lens of a master being liable to the actions of a slave. On applying this to the case of Majori, when suing for medical negligence, a hospital can be held to be liable. However, there are three key requirements which must be satisfied in order to conclude a successful claim of vicarious liability. The first is establishing vicarious liability. The three parts of the test in Malaysia is that it operates within a threefold part. The first is that there must have arise an employer-employee relationship. The second is that this must have been followed by a tortious act by the employee, and finally, this act has to be during the course of employment. Given the case facts, it is seen that the resident medical officer given the case facts in the question, it is seen that the resident medical officer implies that they are inexperienced as compared to other doctors who have worked in the field. This is seen because resident medical officers are normally new to the field and thus may not have that much expert experience or even regular experience as compared to a doctor who has been practicing for a while. However, one may ask, where does the negligence arise for? The resident medical officer fails to give this information of themselves being inexperienced to Majori as she makes this diagnosis. Since it has been established that she owes a duty of care towards Majori, this extends to a duty of disclosing such information of inexperience. This rule was marked in the judicial precedent under the case of Gurisha Tanjit Kaur and another versus Dr. Primita Damadaran and another. This case was a case in 2020 where judges ruled that the failure to disclose to a patient on inexperience on handling emergency cases was negligence. Faiza Jamaluddin, who was the judge in this case, mentioned that there is a doctor-patient relationship where there is a doctor-patient relationship, thus there arises a duty to diagnose, advise, and treat. However, in the case of Majori, it has been seen that the medical officer makes the diagnosis before formally undergoing any ECG, which any emergency center of a hospital has. So the negligent act lies in the failure to disclose inexperience and as well as making a diagnosis of angina before actually undergoing a simple test such as that of an ECG. So thus far, we've concluded that there are two negligent acts, thus satisfying the first part being that there has to be an act of negligence. Second, on applying the threefold test criteria to the question, the medical officer must first establish an employee-employer relationship with the hospital in order to prove that the person is working under a contract of service, rather a contract for service. Well, UK Supreme Courts have applied, a UK Supreme Court test was applied and adopted by Malaysian courts. This is a famous case that was held in 2018, Dr. Kok Chung Seng and another versus Su Cheng Lin and another. So during this case, the federal court established that the close connection test is sufficient to deduce an employee from that of an independent contractor. The case above had the ruling, in the Malaysian case above, the ruling was applied from the case of Catholic Welfare Society versus Institute of Brothers of the Christian Schools. Over here, both stage 1 and stage 2 of the test were used. Stage 1 test is the close connection test, as just mentioned. And under this test, the medical officer must satisfy 5 main criteria in order to enforce vicarious liability upon a hospital. So looking at stage 1 of the test has 5 parts. So stage 1 refers to the close connection test, and the close connection test has 5 main parts. The first part is that the employer is more likely to have the financial means to compensate the victim, in this case being Majori's, in this case, this is Majori's disease, being anyone who is filing suit in behalf of Majori. So this poses to be true as the employer in the case does have more financial abilities to compensate the victim as it is a hospital. The second part of the test is, was the tort committing during activities for the employer? Applying the case facts, it is seen to be true. As a resident medical officer was working during emergency hours for the hospital, the tort of negligence mentioned above was committed then. The third is the activity, is it part of an employer's business? The employer is the hospital, and yes, indeed, employing medical officers is part of the business, and the medical officer was undergoing his or her duty in the emergency center. So yes, this part of the 5-part test is also true. Now, the fourth part is, did the employer create the risk by employing the tortfeasor? Applying this to the case, it can be seen that this is also true, such that employing a resident medical officer to an emergency department where there are a lot of cases that require experts and require fast-paced movement, a resident may fail to operate under such high-pressure environments. So it can be said to be unreasonable for the hospital to have allocated the resident in the emergency department, and thus it is an unreasonable standard of care that the hospital used. The case of Gold versus Essex County Council clarifies that an employer needs to take reasonable levels of care in employing a competent staff. So when using this judicial precedent, it is very clear that a resident officer should not be in an emergency department. Now, finally, the last part of the close connection test was, is there some degree of control by the employer over the wrongdoer? This can be said to be the most clear indicator of establishing vicarious liability, because the hospital has a great degree of control over an employer. Thus, the hospital has the potential to be held vicariously liable on behalf of negligence of the medical officer. Stage 2 of the test refers to when it must be during the course of employment that the negligent act was committed. And in this application, it is true, as a negligent diagnosis and failure to disclose experience was indeed done during the course of working hours within the emergency department. Now, having established the stance on vicarious liability and how the hospital can be held vicariously liable on the behalf of the negligence of the medical officer, let's move our attention to the consultant cardiologist. Malaysian law looks at the consultant cardiologists as people who are independent contractors and not employees. The Private Healthcare Facilities and Services Act of 1998 and the Regulations Act of 2006 both states that hospitals may be liable to providers of care and not only on the facilities they provide. This brings up the doctrine of non-delegable duty. This refers to exceptions in cases where courts have held employers liable, where in this case, the hospital is under a personal duty ensuring reasonable care is taken. An employer ordinarily is held accountable where duties cannot be delegated, more so in the event that the damages are readily foreseeable. The employer is prevented from shifting his duty of care onto an independent contractor. Now, more so, statutory framework also establishes any sorts of pre-existing relationships between hospitals and patients. This is referred to as an antecedent relationship, and I will further going on to establish why this is so important. Moving on to case law, the ruling in Dr. Kok Chung Seng and another versus Chu Seng Lin and another. This case was a 2017 case where it presented that Malaysia does recognize non-delegable duty, and this was held on the basis of the case Woodland versus Essex County Council. This case has been adopted by Malaysian courts, and thus there is a 5-part test that can be taken to be seen if the consultant cardiologist is in fact an independent contractor and whether non-delegable duty applies. So the first part is the claimant is vulnerable or dependent. Applying this to Majori's case, it is 100% true that she was dependent on the diagnosis of the resident medical officer, and thus this dependency also carried on onto the consultant cardiologist as an ECG was needed to confirm the diagnosis. The second part, there is an antecedent relationship that places the claimant in the actual care or custody of the defendant. This refers to any sorts of pre-existing relationships between a hospital and a patient, as a patient is under the care and custody of a hospital, giving rise to the presumption of positive duty to care for the patients. Such a relationship is provided via Malaysian statute under the Private Healthcare Facilities and Services Act and its regulations. This is where there is an automatic pre-existing relationship established within the Act. Now, applying it to Majori's case, Majori was admitted via the emergency department and received care from the resident medical officer. This creates a pre-existing custodial relationship between herself and the hospital. Thus, the medical officer, when referred Majori to the consultant cardiologist, is still part of a chain under this relationship, as duty of care doesn't only extend towards diagnosis, but that of treatment as well. And now looking on to the next part is, does the claimant have no control over how the defendant performs its duty? Looking at this, the answer is yes. Majori had no practical control over the cardiologist's selection or her emergency care. This fulfills another feature to the test. Now, looking at the last feature, the hospital has delegated an integral function, such as surgery or treatment, to someone else. Now, looking at it, we can say, has negligence occurred in the delegated function? And it is not something which is collateral. Now, when looking at it, yes, the hospital did in fact delegate an integral function, and this integral function was that of diagnosing, and the diagnosis was done by the resident medical officer and was supposed to be confirmed, however, was confirmed negligently and wrongly by the consultant cardiologist. So when really looking into the details of the case, the negligence arose in misreading, and it happened part of care delivered within the hospital setting. Again, the courts in the case of Dr. Kok stated that non-delegable duty applies where it is found to be fair, just, and reasonable based on circumstances. Such circumstances refer to if patients expressly choose their doctors, then liability may not follow. However, this is not the case in Majori. Majori came as an emergency patient, and she did not expressly concern any sorts of requests towards meeting a specific consultant cardiologist. The cardiologist was addressed and given to her without her knowledge. So to conclude, yes, the hospital does have the possibility to be held liable for both consultant cardiologists hospit's negligence, and as well as that of the resident doctor.
Greetings to Dr. Maini. Today we are dissecting a critical area of Malaysian jurisprudence, the doctrine of institutional liability for private healthcare providers. Our analysis centers on the hypothetical but legally potent case of Marjorie, who tragically passed away following a failure to correctly diagnose and treat an acute cardiac condition in a private hospital setting. This outcome immediately raises critical questions regarding medical negligence, but more significantly, it demands an examination of institutional liability under Malaysian law. Now, Marjie's family has strong grounds to initiate a suit against three parties: the private hospital, the resident medical officer or RMO, and the consultant cardiologist. Their cause of action rests on a powerful confluence of common law principles, which are specifically statutory duties, and recently a game-changing judicial precedent. Now let's speak on the landmark shift, Siu Ching Yi and the non-delegable duty. This entire legal landscape for private hospitals has been profoundly reshaped by the Federal Court's landmark majority decision in the 2024 case Siu Ching Yi versus Columbia Asia Sdn Bhd. This ruling moves decisively beyond the traditional constraints of vicarious liability and establishes a new paradigm for institutional liability and responsibility. Now, historically, private hospitals often shielded themselves behind the independent contractor defense. However, they would argue that since specialist consultants were not employees, the hospital could not be held vicariously liable for their negligence. Now, this position has been fundamentally challenged and effectively eliminated by the Siu Ching Yi judgment. The court now established that a private hospital owes non-delegable duty of care in NDD to its patients, especially when providing core essential services like emergency diagnosis and care. This is a personal, positive duty that the hospital assumes. The court also examined the provisions of Private Healthcare Facilities and Services Act 1998. Justice Mary Lin Tiam Soon, delivering the majority judgment, held that the legislative scheme clearly intended private hospitals to be regarded as active providers of treatment and care, and not merely as providers of premises or utilities. This statutory framework satisfied the court that the hospital had assumed a personal duty to protect the patient from harm, and a duty that absolutely cannot be shared, relinquished, or delegated to a private consultant through a contractual terms or however otherwise. Now let's move on to applying the principles, which is dual liability in Marjorie's case. The consequence of NDD doctrine is clear. The hospital is now personally liable for lapses that occur during the fulfillment of its assumed function of emergency care and diagnosis. In Marjorie's situation, the hospital is liable on two distinct fronts. First, under the non-delegable duty, the hospital is directly liable for the consultant cardiologist's misdiagnosis and the process of reading the ECG and providing a conclusive diagnosis for chest pain in the emergency department. and it is recognized as an integral part of the comprehensive care the hospital holds itself out to provide. And secondly, under vicarious liability. The resident medical officer, RMO, is typically an employee or a servant under a contract of service with the hospital. If Marjorie's family can successfully prove that the RMO's initial diagnosis of angina and the subsequent negligent decision-making contributed to the fatal delay, then the hospital would be vicariously liable for the RMO's tortious act applying the common law master-servant relationship in this case. Thus, Marjorie's family is empowered to hold hospital, the RMO, and the consultant cardiologist jointly and severely liable for the tragic death. Moving on to the financial consequences. Indemnity and contribution. While the hospital's liability to the patient is now firm, the question shifts to its financial recourse against the negligent practitioners. Can the hospital claim indemnity from the doctors? The federal court in Siu Ching Yi was explicit. It dismissed the private hospital's application to be fully indemnified by the independent contractor. Now, the court's reasoning rooted in policy. The non-delegable duty imposes a personal liability on the private hospital itself designed to stand over and above that of the individual doctor. In this case, granting full indemnity would effectively allow the hospital to pass the entire financial burden back to the individual tortfeasor, thereby negating the entire purpose of holding the institution personally liable in the first place itself. Moving on, consequently, the private hospital in Marjorie's case cannot seek to be fully indemnified by the consultant, this cardiologist or the RMO. However, all three parties are likely to be held liable as concurrent tortfeasors. This situation triggers the right to contribution under Section 10 of the Civil Law Act 1956 Act 67. This provision allows a tortfeasor who has paid damages greater than their equitable share to recover a contribution from any other person also liable for the same damage. The court will determine the amount of contribution that is just and equitable, having regard to the extent of each party's individual responsibility for the damages itself. Therefore, the hospital can compel the doctors to bear a proportionate of the total damages awarded. Now let's speak on the statutory divide, public versus private hospitals liability. Finally, it is essential to highlight how this liability contrasts with claims against public facilities, as the treatment of hospital liability in Malaysia is defined by two distinct statutory regimes. Private hospital liability is strictly regulated by the Private Healthcare Facilities and Services Act 1998, Act 586. As established in Siu Ching Yi, this Act provides the statutory underpinning for the NDD. The failure to maintain quality and safety standards as required by the Act forms the precise basis of the hospital's personal tortious liability. This is a direct, policy-driven liability model emphasizing institutional accountability, and it lacks additional procedural barriers for the claimant. Now, on the other hand, public hospital liability conversely is governed by the government, and this is by the Government Proceedings Act 1956, Act 359. The primary mechanism here is vicarious liability for the torts committed by its public officers. Section 5 of Act 359 makes the government liable, but this liability is subject to crucial limitations. Most notably, Section C subsection 1 requires that proceedings for damages must first have lain against the public officer personally. Furthermore, the Act imposes a significant procedural constraint. The claimant must provide a formal 2-month notice of intention to sue the government before actually commencing the action, and a requirement entirely absent when suing a private hospital. In essence, the PHFSA actively imposes a direct institutional duty on private hospitals, while the Government Proceedings Act passively assumes the government's vicarious liability for its employees. Subject to restrictive statutory conditions, of course, and procedural requirements. In conclusion, Marjorie's family has a potent and legally robust cause of action against all 3 parties, fundamentally supported by Sue Chin Yee's decision. This ruling is crucial because it eliminates the private hospital's primary defense and holds the institution personally liable under a non-delegable duty of care rooted in the PHFSA 1998. While the hospital cannot claim full indemnity, it will be compelled to seek contribution from the negligent doctors. The entire case highlights the divergent legal approaches in Malaysia, where private sector's liability is now governed by the PHFSA's emphasis on direct institutional accountability, and in stark contrast to public sectors, which relies on the more constrained employment-based vicarious liability provisions of the Government Proceedings Act 1956. Now, this landmark case marks a significant step forward in ensuring justice and accountability within the nation's healthcare system. Thank you so much.